Joining us now is Misty Marris, trial attorney and legal analyst. Good morning. Thanks for being with us on the weekend.
Good morning, Anna. Happy to be here.
So, big day tomorrow. What can we expect from these opening statements?
So the opening statements are going to be the lay of the land for the jury. It's going to introduce the jurors to both the prosecution's case and what the defense intends to show to refute the prosecution's case. So prosecutors are going to focus on the elements of the case. It's about falsifying business records. And the reason that it's a felony is because the reason to falsify those business records is to cover up another attempted crime, which are campaign finance violations. By making these payments, saying that they're legal expenses, that violated those laws or was an attempt to do so. Now, the defense, they're going to say Donald Trump is not the one writing this is what the business expense is in a ledger. That's delegated to other people, and that there was no violation of the underlying law. So the whole thing should result in an acquittal. And that's what we're going to hear in the openings tomorrow.
So I imagine we'll kind of hear promises from both sides. Do you think the defense will promise that Trump will take the stand? He said that he wants to, or will that be kind of a game time decision and they won't mention it tomorrow?
He's made that public statement many, many times, but there are so many factors that go into that analysis. And in general, from a defense perspective, it's a game time decision. You let the prosecutors make their case. They have the burden of proof, and then you make a decision about whether or not that testimony will be helpful. Another thing, Anna, a huge component of this is the results of what's called a Sandoval hearing, which we'll hear the judge rule on tomorrow morning. The arguments for Friday, the judge will make a determination about what is up for grabs in the cross-examination. Prosecutors want to bring in all sorts of what they call prior bad acts, the E. Jean Carroll civil trial, the trial by the Attorney General, the civil fraud case against Trump and the Trump Organization. They want to bring that in. Defense is countering that and saying it's not relevant. So the results of that hearing will be very impactful on the analysis of whether or not he takes the stand.
And what about his behavior in the courtroom, this week and the weeks upcoming? Last week it was jury selection. Some said looked like he was falling asleep. You can't imagine he's going to be feeling low energy, though, when people are saying things that he disagrees with. And just knowing his personality and being the former, arguably, most powerful man in the world, how could his behavior impact this case?
The jury is always watching. So what a defense attorney is going to tell a defendant, any defendant, but in this case, Donald Trump, obviously all eyes are going to be on him, is to be engaged. You have to take this seriously, no matter what you think about it. You are sitting at that defense table. Be engaged, listen to the testimony, listen to the witnesses. And of course, we know that he makes these comments outside on the courtroom steps, but that type of behavior and conduct cannot come into the courtroom because, Anna, the judge, if he is disruptive, has the ability to actually kick him out. And that would be a worst case scenario because he needs to be there in this case and does not want to have those types of sanctions against him during the course of the trial.
There are kind of these two different parallel trials going on, the one that we're seeing outside of the courtroom and what's going on inside the courtroom. The graphic that we were just showing there of the makeup of the jury, two of them are attorneys, and we had an attorney actually on yesterday who brought up the fact that he was a bit surprised that both sides were happy to have two attorneys on there, in that the other jurors may look to them when they have legal questions, when they should not be asking other jurors, they should be asking the court, right? Is that something that you noticed that was sort of a point of concern, or not really to you?
Oh, absolutely. As someone who's conducted voir dire many, many times in New York, and also I got called for jury duty, I've never been able to sit on a jury because oftentimes you get rid of lawyers. And the reason to do that is because they have a certain level of authority in that jury room. So you put a lot of faith on that person to be a leader, and other jurors will oftentimes follow because they do have that specialized expertise. So it is certainly a risk to put lawyers on a jury. However, in this case, I do think there's a counter-analysis because as much as everybody refers to this as the hush money trial, it is actually a very, very complex legal case relating to the falsification of business records and also this underlying issue of whether or not it was for the furtherance of another attempted crime. So in that sense, it could be beneficial to have a lawyer in that jury room who's thinking about it from that perspective with a really, really legal eye towards those types of issues. So I think that's why you actually see these lawyers making it through jury selection.
Yeah, I don't think the complicated name that you just mentioned would work. Hush money trial just sounds so much catchier. So everybody's going to stick with that one, don't we?
100%.
Yes, Misty Marris, I really appreciate you coming in on a Sunday. Appreciate it. Thanks so much.
Thank you so much for having me.
22 minutes after the hour.